case law update. You'll see some slides scrolling here that tell you about our speaker today, and I will introduce her in a moment. But first, I'd like to say thank you for attending, and that this is the fourth session in the webinar series of the 2021 Joint Planning Conference of the New York Upstate Chapter of the American Planning Association and the New York Planning Federation. My name is Marcia Keyes. My colleague Mark Castiglione and I will be your host for this session today. We'd like to thank our premier conference sponsor, Hodgson Rush Attorneys, and the sponsor for this session, Whiteman, Osterman, and Hanna. Without our partners, this virtual conference would not be possible. We want to let you know that all of the sessions are being recorded and will be available online through the New York Upstate Chapter YouTube channel. Links will also be provided on the Eventbrite event page as the videos become available. All attendees are automatically muted, so if you have any questions, please put them in the Q&A box. We will address as many questions as possible, either throughout the session or at the end of the session. The session is intended to go until 1:30. So there will be 1.5 continuing maintenance credits, and I will put that number in the chat box as well. So our session today features Teresa Baekner, Esquire. Ms. Baekner is a partner with Whiteman, Osterman, and Hanna, LLP, where she represents clients and permitting, administrative, and enforcement proceedings before state and federal agencies. She specializes in obtaining land use approvals for commercial, industrial, residential, and energy projects, and is an expert in brownfield redevelopment, wetlands laws and regulations, protection of endangered species and critical habitats, and the preservation of archaeological and historic resources. She chairs the firm's Clean Tech Practice Group. Ms. Baekner is a graduate of Penn State and Albany Law School. So we're very pleased to have someone with her expertise provide us with information about the important land use issues of today. So I'll now turn the presentation over to Teresa, and we have her PowerPoint up on the screen. So Teresa, whenever you are ready, please take it away.
All right, thank you very much. I'm very happy to participate and help out with the organization's wonderful training goals. I think she made my presentation sound far more exciting than it in fact will be. But the goal here today is to do a case law update, which will provide planning and zoning board members with a good perspective on how courts in New York State review how they're doing their job. So there are very many cases in New York State where people have chosen to challenge decisions by zoning boards of appeals and planning boards. And the whole goal of this presentation is to discuss the most recent cases and point out ways in which municipalities can be careful to follow the procedural requirements and also get a sense of how judges view their decision making. We've been doing these case laws updates for a long time. And the only thing I will say about this year is that understandably, I think there are fewer cases out there because the courts were certainly affected by COVID, as have we all been affected by the pandemic. So we'll just go through the cases. I'm happy to answer questions as they occur to you or at the end, really whatever works, and Mark's going to help us do that. I have loosely categorized the presentation by the type of review that's being challenged in court. And our first group of cases relate to site plan review primarily. So Mark, if you could go to the next slide as well. The first case we're going to talk about today is Favre versus the Planning Board of the Town of Highlands. This is a relatively what I would say, non-remarkable project where someone came in for site plan approval for a hotel and restaurant. The adjacent property owners were not pleased with the decision that the planning board had made in issuing site plan approval, and also the grant of a special exception use permit, which I always think of as a special use permit because they're basically very similar. And they argued that the planning board did several things wrong. They contended that the planning board needed to hold another public hearing because the site plans were revised during the process. They also contend that the planning board was required to re-refer the application to the county planning board pursuant to the New York State General Municipal Law. And then lastly, sort of a catch-all argument that the planning board failed to comply with seeker in issuing the negative declaration. So nothing unusual about this case. It's basically a mixture of procedural allegations and then a flat out disagreement that the planning board complied with seeker appropriately. So this is a very typical case in that the courts basically supported the planning board's decision, and they looked at the facts as it related to the application process. And in particular, the court found that the modifications to the site plan after the public hearing was held were not so substantial that they would require an additional public hearing. In fact, the changes did not expand or change the basic layout or dimension of the projects. So whatever these changes were, they were not substantial changes. Similarly, the court indicated that the changes were not so substantial as to require the re-referral either. Lastly, the court looked at the issue of the negative declaration, and they found that the board identified the relevant areas of environmental concern as related to the project, took the requisite hard look, and made a reasoned elaboration of the basis for the determination. So the petitioner's claim, if you could move forward to the next one, the petitioner's claims failed on all three counts. What you find a lot with respect to these cases is that the owners of the property that are challenging the approval have generally an economic reason for not wanting to see a hotel next to it. And in this case, the petitioner's property was an automobile body shop and a gas station. And apparently they had a concern about the use of the property in the way that was proposed as a hotel and a restaurant. But from an environmental standpoint, they had failed to articulate any basis for showing that the planning board should have made a different decision. So our next slide is for the Empire import-export case. This is down in the town of East Hampton, and it has to do with a gas station canopy and an allegation in this case by the ones who did not get the permit that they should have been awarded a permit by the East Hampton Planning Board. And the court looked at this allegation and looked specifically at the criteria that the planning board had looked at. And they said, here the planning board properly considered whether the proposed project was consistent with the uses surrounding properties and whether it would bring about a noticeable change in the visual character of the area. So the court of in this case, the Supreme Court Appellate Division, Second Department, upheld the planning board's determination, finding that they had a rational basis for denying the request for a very large canopy. Next slide, please. Next slide, please. The next case is Gershaw Recycling of Riverhead versus the town of Riverhead. And this case has to do with an issue of who has the authority to make the determination. And in this case, the town code was a little bit different. It authorized the administrator of the building department to review, evaluate, judge, and advise on applications related to the town code, and to make issue and render determinations regarding compliance with the provisions of the zoning code for site plan applications. Now, in every municipality, generally speaking, the building inspector has the authority to make a determination whether or not a particular use is allowed in a zone based on the criteria in the zoning code. This town code had an administrator of the building department, and the fact that there was an administrator sort of led them down a path where the town building and planning administrator thought that their authority was the same as the planning board's authority with respect to site plan applications. And the court, really looking at the New York town law and looking at the zoning code in the town of Riverhead, determined that no, the administrator of the building department had exceeded his authority in determining that a site plan approval could not be granted for the project. And so looking at the town codes, specifically vesting the planning board with authority to act on site plan applications, the appellate division remitted the application to the planning board for further proceedings. So essentially, somebody got out of their lane. The town building and planning administrator exceeded their authority, made a determination, which was then challenged, and the appellate division sent it back to the appropriate body, which would be the town of Riverhead Planning Board. So an interesting case. That's not something you see very often because, you know, usually it's pretty clear who has responsibility for what. Next slide, please. This is Katie versus the town of Germantown Planning Board. This is an interesting case because the project that was being reviewed was a Dollar General retail store, and they made an application for site plan approval, and the building design included a 71-foot facade. Now, this particular project went through an environmental impact statement process, which was quite lengthy, took a number of years. And at the end of it, when the planning board adopted seeker findings and issued site plan approval, there were still people that were unhappy with the approval of the project. One of those people being the neighboring property owners who were substantially removed from the property, but still within the line of sight of the property that was proposed to be developed. And the technical argument that was made here was specifically that the planning board exceeded its authority because they approved a 71-foot facade without having an area variance that was granted by the Germantown Zoning Board of Appeals. The court determined that a Zoning Board of Appeals area variance was not necessary for this project because, in fact, the planning board had the authority to waive what was a guideline and not a compulsory requirement. By way of example, the zoning code did not say you shall not approve a facility with 71-foot facade. Instead, it said that it was a guideline. It said will generally not exceed 71 feet. And the other thing that the court pointed to was that the planning board had directed that the facade be altered during the process as a way to reduce the visual impact. So here we have a Dollar General store going through a 4-year process of environmental review in which the planning board looked at all the issues very carefully and had a very clear record as to what it was determining with respect to the visual impacts of the facility, as well as the facade and mitigating measures that had been adopted. Not surprisingly, the court, in this case, the Supreme Court Appellate Division, 3rd Department, determined that the planning board had acted fully within the scope of its authority and also had more than complied with seeker for what was a relatively small project. All right, next slide. Thank you. So the next case that we have is matter of I'm gonna mangle this and I apologize, Sagaponack Ventures LLC. And this one is one of those where you could say that it was a peripatetic project. So the petitioner in this case was applying for site plan approval for a project involving the development of a 13,000 square foot single family residence on his or her property. Now, they had previously applied for several other projects. And each time the planning board had told them that they did not want to see the northwest corner of the property developed. So it's almost like the petitioner kept coming back with lots that they were seeking to get approved, including a lot in this northwestern corner of the property. And their last ditch effort was to show nothing else but this particular 13,000 square foot single family residence on the northwest corner. And so what the court did is they looked at the basis for the planning board's decision that the northwest corner of the property was not a suitable location for the development. And they looked specifically at the standards that were cited by the planning board, including that the development would negatively impact the views and vistas of farmland areas, and that it would have a negative impact on any future subdivision of the property. So you can keep coming back to the well, but it doesn't mean that you'll eventually get your project approved, especially where it's pretty clear that you're trying to, work the system in that regard. So the next group of cases are special use permits. And the first one we'll start with is near and dear to my heart, which is the Biggs versus Eden Renewables case, because this is one that we handled on behalf of the municipality. This is one of those very contentious cases known as solar energy, utility scale solar energy systems. This was 2 projects adjacent to each other, 2 5-megawatt solar panel arrays. And the town of Duanesburg has a local law that regulates solar projects, and it also integrates it into the site plan and special use permit process that's in the zoning code. And a permit after a year of review and the adoption of a negative declaration was granted to Eden Renewables. An adjoining property owner objected to the issuance of the special use permit. So the court, in this case, the Supreme Court Appellate Division 3rd Department, upheld the determination of the planning board finding that the arguments made by the adjoining property owners were not well-founded. They looked at the negative declaration that was issued, and they looked at the special use permit and approval that was, and site plan approval that was granted, and determined that all of the record showed that all the requirements of local law number 1 allowing such facilities had been met. And they pointed to the fact that there were 2 public hearings. There was a full environmental assessment form and supporting studies, including sign-offs from the county, the New York State Historic Preservation Office, a fully compliant stormwater pollution prevention plan, and also a resolution articulating the basis on how it met the requirements. Also in this case, the opponents chose to raise concerns, but they never submitted any expert testimony whatsoever, so that in the event the planning board had listened to the objections and denied the request for the permit, there wouldn't have been a rational basis, because it would have been denying a special use permit solely on community opposition. And also there were changes made to the project to address the concerns of the adjoining homeowners, including requiring a 1,600-foot evergreen barrier. So I guess what this case stands for is that if you have a record that demonstrates that you looked at all the issues, that you listened to the public, and that the public comments were addressed by the applicant and project changes were made as well, that a decision to issue a solar permit, a special use permit, excuse me, for a solar panel project can be upheld. Next slide. This is Edgewater Apartments versus New York City plan. We don't usually include a lot of New York City cases in these presentations, just because they're quite a bit different procedurally, and they have the City Environmental Quality Review Act and the Uniform Land Use Review procedures which apply. But this one was interesting, primarily because it was a project that was not subject to ULURP, because it had been approved previously under the zoning, and a special permit had been granted. And then there were allegations that the project had been changed to a great degree and therefore required more environmental review. And the court basically determined that that this would have been a decision in essence to rehear the case, and that there was no basis for doing that in the law. So this was a lapse of about 10 years from the permit's original effective date. And it is common for people to argue that you have to recommence environmental review, but the courts are not very sympathetic to those arguments. And this is just another one in a series of cases that makes that determination. The next case is the seeker case. I think we skipped one there. Can you go back to the matter of Council of City of New York versus Department of City Planning? This is another case in which the courts are looking at a previously issued permit and determining that because the special use permit was issued for the project, even changes in the project, in this case, the proposed towers being more than twice the height of the surrounding buildings, they were still in compliance with the applicable zoning regulation. And this one is also interesting in that there were a number of involved and interested agencies. And this is one of the few cases in which the court looked at a situation where the seeker review had been previously done, and they looked at a lot of technical arguments relative to whether a new special use permit would be required just because of the size of the project. And the courts determined that no, because it was authorized by the zone, there was no requirement to obtain a special use permit for the project. So again, it's what you would call sort of a streamlined approach where the project as designed complies with the zoning, and that for many people that were involved in the project was unacceptable. The opponents wanted to have an opportunity to have public hearings and to look at the project and whether or not it should be approved in that area through the lens of a special permit process. Next slide. This is a series of new seeker cases that have come out really in the past 2 or 3 years. This one is also interesting because it involves affordable senior housing and the somewhat different process that you go through in order to review and approve senior housing. So this was Cobb's Hill Village, which was demolishing some current apartment buildings to replace them with modern apartment buildings for affordable senior housing. And there is a lot of funds out there these days for renovating or rebuilding affordable housing. So you'll see these cases, I think, fairly frequently. So in this case, there were a number of involved agencies, including the mayor's office, the City of Rochester Planning Commission, and the City of Rochester zoning manager. These entities had agreements in place as to who would be lead agency for the seeker review. And the court found that they followed their internal agency's agreement for who's it to be lead agency. They also had to issue an approval. The City of Rochester Planning Commission had to issue an approval for the project. And the lead agency, which was the zoning manager, was looking at the negative declaration, or excuse me, looking at the environmental assessment form and deciding whether to issue a negative declaration. Not surprisingly, there were a lot of people very concerned about the project, specifically tenants and residents of adjacent neighborhoods. And they asked the court to annul the lead agency's negative declaration, the planning commission's conditional approval of the project, and the planning commission's determination that the revised application should have been re-referred to the county planning department under the general municipal law. The courts, again, have not been and are not in this case particularly sympathetic to the suggestion that because there are, different agencies that could act as lead agency, that the agencies in this case acted in any way that was inappropriate. And the courts looked at the involved agencies and the agreements that they had with respect to who would be lead agency. And they found that, that it was an appropriate lead agency. They said, we conclude that ultimately the zoning manager properly acted as lead agency on the project based on the overlapping standing agreements between those entities. And they specifically looked at, was there some sort of improper delegation of seeker authority? And they found that no, there was not. And moreover, they determined that the zoning manager took a hard look and provided a reasoned elaboration for the basis of the negative declaration that had been issued. And the two issues that were raised in this particular case were traffic and lead contamination. And the court specifically looked at the record with respect to the traffic and found that both an independent traffic study was undertaken by an outside firm, which was reviewed by the Monroe County Department of Transportation. And both the study and the Department of Transportation determined that the project would not result in an impact on traffic safety or in a significant traffic increase during peak hours of travel. So the next issue that they looked at was lead contamination. They had done a soil study and they had found no indication of any lead or other harmful metals located on the premises. And there was an allegation made in the court papers, but not in front of the zoning manager or the CPC, that there had been an outdoor shooting range operated on the property 100 years ago. The court was first found that procedurally raising that argument at that time was inappropriate. And two, that there was no indication that the soil study that they had done was in any way inappropriate or not substantial enough in light of such, historic allegations. The other thing that they looked at was this issue of, did they need to re-refer it again to county planning? And the court again dismisses that argument, saying an agency is not required to provide multiple referrals to the planning agency unless revisions to the project are so substantially different from the original proposal that they should have an opportunity to review and make recommendations on the new and revised plans. So the courts are basically signaling that, just alleging that they didn't refer something back is not going to be enough. You have to show why it was so substantial that a second referral was necessary. And it says, the project's footprint as originally submitted to the planning department was basically the same as the footprint as was eventually approved. They also had a very small discussion of the findings that the CPC looked at in terms of the 5 factors for determining whether to issue their approval. It's interesting, the court just said, yes, they looked at the 5 factors, so they didn't discuss it in any great detail. Again, another case that shows that the courts are going to go out of their way, generally speaking, to uphold the record where there's enough information in the record to demonstrate that the board considered all the adverse environmental impacts and made a written, well-reasoned decision. They specifically said, although the number of apartment units to be constructed and the height of the buildings have increased since the original referral, the changes to the project when viewed in its totality were relatively minor. A lot of times people who are involved in the review of projects express some frustration over the fact that the project changes over time. And the reality is seeker and the land use review process contemplates that that's what's going to happen. And so just the fact that something changed, it does not warrant going back through all the procedures. Next slide, please. The next case involves a $1 million+ warehouse distribution facility. In this case, this was a sales distribution facility under the zoning code of the town of Schodack. And the argument here was simply that because it was so large, the project, over 1 million square feet, and because it was a type 1 action, that per se, there had to be a draft environmental impact statement. And the court rejected that argument. The court determined that the planning board, that was the lead agency for the seeker review, although they didn't prepare an EIS, they considered a very substantial environmental assessment form accompanied by numerous technical reports that fleshed out the project with respect to geotechnical concerns, stormwater management, and traffic impact studies. The court also found that the sales distribution center was an approved use in that zone, and that because of that, and the attention that the planning board had paid to all the issues that were raised by the public, that there was in effect no reason to reverse the planning board's negative declaration or annul the grant of special permit and site plan approval. And the court spent a lot of time going through the process that the planning board had followed in the case. They specifically noted with approval that the planning board had had a number of opportunities for public comment, including 2 public meetings at which public comments were accepted. All the information was made available to the public from the town website. The town of Schodack did an excellent job of putting all the documents up on the website and making them available to the public easily. They also did a traffic study, an intensive traffic study, which was then reviewed by the New York State Department of Transportation and the town's engineer, and was approved by both. The court relied heavily on the fact that the Department of Transportation had agreed with the conclusions of the traffic study, and also the intersection improvements that were going to be undertaken as part of the project. Another issue that was raised was fire company concerns. There was a volunteer fire company in the area, so there was an enormous amount of information in the record regarding a state-of-the-art fire suppression system that is part of the sales distribution center. And the court also said, finally, the record discloses that the area for the project was already zoned for distribution facilities, and the project was consistent with the community's character. So they upheld both the seeker determination and the procedure that the planning board followed, and their findings with respect to the special aquifer permit as well as the site plan permit. One of the arguments that was made was just simply that it was too big a project not to require an EIS, and the appellate division as well as the Supreme Court underneath rejected that contention. The other contention was that it was just approved too quickly. And that's kind of an unusual argument, at least in New York, because things generally don't get approved quickly or even within the time frame specified in seeker. And the court found that the regulatory scheme does not provide for a minimum time frame, only maximum timeframes by which the lead agency must act. So doing something quickly, if true, is not a claim that it was done inappropriately. Next slide. This is a matter of Peachin versus the city of Oneonta. It's an interesting case where the city of Oneonta Planning Commission authorized the construction of a affordable housing apartment units, as well as an educational facility. So it's mixed use, but somewhat unusual and very much rooted in Oneonta. It specifically indicated that there was going to be interaction with the college there, Hartwick, and also an institute having to do with farm to table type aspects of the project, almost like a study for enhancing, agricultural products and uses in the area. The City Planning Commission served as lead agency, and the Planning Commission issued a negative declaration and approved the project, waiving a zoning code requirement that 90 off-street parking spaces be added to accommodate the use. As a result, petitioners who were adjacent property owners challenged the decision, and their primary challenge was that the commission had failed to take a hard look at the parking impacts of the project. And in this case, the Supreme Court looked at the arguments that were being made, how they were being made, and basically determined that this is a case where people with an economic interest were attempting to make seeker arguments that really didn't rise to the level that would make them cognizable under seeker. Instead, what they were arguing was, if you approve this project, it will damage our business, and that was simply not something that is contemplated as a claim under seeker. But the court, as the courts often do, and this is the Supreme Court Appellate Division, 3rd Department, looked at, okay, even if they had standing to challenge the negative declaration, did the planning board do a good job in looking at the alleged harms that the petitioners say that they're going to suffer? And they specifically found that the Planning Commission had carefully looked at the visual impacts of the proposed structure, and that there were no officially designated scenic or aesthetic resources located within 5 miles of the project, and that they had carefully looked at the parking, including in sort of an overall comprehensive sense throughout the city as part of the city's downtown revitalization plan. So there was long-term planning that had taken place, and there was also an evaluation of the parking that would be available after this specific project was built. And the court declined to disturb the City Planning Commission's determination with request to the parking, specifically finding that there was enough in the record to establish that parking would not be adversely impacted by the implementation of this project. They also attempted to make a public trust doctrine argument, because the property that the mayor and the city had decided to convey for the project had been held by the city for many years as public parking, and it had been given to the city for park and municipal purposes only. And the court, specifically looking at this argument, said, yes, the public trust doctrine applies to the transfer of such property. However, where the transfer of the property continues to serve a public purpose, no violation of the public trust doctrine occurs. So they determined that because the land would be subject to continuing public use, and it was benefiting it was a benefit to the city by providing affordable workforce housing for artists and middle income residents, and that it was leading to the redevelopment of the area in addition to containing exhibition spaces for artists and for the Hardwick College Grain Innovation Center, that there was still a public trust or public purpose that was being served. The other interesting thing about the parking approval that was granted by the City Planning Commission was that the Planning Commission itself had an ability to waive or vary the parking requirements. And the court found that the Planning Commission's decision to do so was sufficient to support the decision. And the petitioners argued that they needed to get a zoning board of appeals approval, something along the lines of an area variance for it. And the court determined that no, that wasn't necessary if the planning board had the ability to waive the parking requirements. So it's a very interesting decision, touching on a number of important things, particularly the public trust doctrine. Next slide, please. The next case involves reuse, or I guess you would say reuse or expansion of uses on former church or current church properties. So this is a proposal to renovate Trinity Episcopal Church and Rectory, involving sort of, in this case, non-church uses. So they were going to construct an inn with guest rooms, a restaurant, and they were going to expand the parking lot. They were still continuing the church use on the property, specifically the church sanctuary, but it seems fairly obvious from the review of the case that this was a situation where the church no longer needed all of the property that had originally gone with the church building proper. And not because churches are often in areas that are non-commercial, often residential, and that was the case here. They were directed to go to the Zoning Board of Appeals of the City of Geneva. And the Zoning Board of Appeals acted as the lead agency, issuing a negative declaration and approving the use variance. And it's an interesting case because, as we all know, there are many former church properties or properties formerly associated with churches which need to be reused, adaptively reused. And in this case, the court really deferred to the determination of the ZBA that the applicable zoning regulations and restrictions would cause unnecessary hardship. And so they went through the typical standards that they couldn't realize a reasonable return with respect to the property, that the hardship was unique, and that the variance would not alter the essential character of the neighborhood, and that the hardship was not self-created. Many of the church properties predate any kind of zoning. I imagine that was the case here as well. They also upheld the negative declaration that was issued. It was a type 1 action, because of the historic nature of the property, I believe. And again, there's this argument that because it's a type 1 action per se, you have to go through the environmental impact statement process. And the courts denied that. They determined that the negative declaration was a written, well-reasoned decision, and that there was no reason for the court to second guess the ZBA's determination. There was also an argument that they were denied the right to participate in the public hearings before the ZBA, and that additional materials were submitted after the deadline for submissions had expired. And the court determined that they commented on the issues, the petitioners commented on the issues at the hearings and made written submissions. And again, this concept that you can't have additional information provided to address concerns without restarting the whole process is just not an argument that the courts are going to have any sympathy with. At least here, where the people who were complaining had an opportunity to comment and participate in the process. The next case that we have here has to do with a brew pub in the town of Half Moon. Generally a popular activity, although not in this case. There was quite a history here of a neighbor who opposed the development of a golf course and a golf clubhouse with restaurant. And that had preceded this case a number of years. Then the Fairways of Half Moon LLC, the applicant came in and asked to be able to add a brew pub to the existing bar restaurant. No doubt because they're very popular these days. So the petitioner's neighbors challenged the determination that the planning board had made that the brew pub would not cause a significant adverse environmental impact, and they issued a negative declaration. They also attempted to challenge the approval of the brew pub on the grounds that it was a commercial activity or facility which was not allowed within this zoning district, although country clubs and other recreational uses such as the golf course were permitted. So in some sense, it was a second bite at the apple over the clubhouse and restaurant, and with the added argument that the brew pub was something new and commercial that couldn't be allowed in this district. And so the court, although there was some confusing language in the record, found that the planning board had appropriately determined that the action was an unlisted action under seeker and issued a negative declaration, which was substantive and looked at the few potential environmental impacts arising from the brew pub, including parking and access issues and concerns as to the disposal of the brewing byproducts. The planning board issued a neg deck and approved the issuance of, or the amendment of the special use permit to authorize the use. It is interesting, however, that the court said, in our view, although it might have been better for the planning board to set forth more of a reasoned elaboration for the basis of its determination, this particular record is adequate for us to exercise our supervisory review to determine that the planning board strictly complied with the seeker procedures applicable to unlisted actions, and the negative declaration it made is supported by a rational basis in the record. So I do think this case stands for being very careful that your procedural determinations throughout the process are clear, the type of the action, and clear as to the reasons why you're determining that there's not going to be significant adverse environmental impact as a result of the project. There was some discussion about an attempt by the opponents to get a determination by the building department that an AR district, that they couldn't get an amendment to the special permit to allow a brew pub in the AR district. But ultimately, the court determined that the planning board looked at all the factors under the zoning code and that they had the authority to allow this use to move forward with a restaurant and a brew pub under these somewhat unique circumstances where there was already a restaurant and a bar present on the property. So an interesting case. The next case is the Black Bear Family Campground. So apparently there was an approved 74 campsite campground, which was illegally expanded to 154 campsites and some accessory structures without seeking any approvals from the town. So you had a certain size campground, which was almost doubled in size, and without any review, seeker or otherwise, because it was simply put an illegal process. So, or excuse me, there was really no attempt to do a process. They just went ahead and expanded it. Now, the town engaged in some sort of an enforcement action against BBFC for expanding the campground. And as a result, they settled the civil proceedings by entering into a development agreement. And in the development agreement, they determined that the campground would obtain an area variance and other approvals in order to get to regularize the campground, if you will, to get the approvals after the fact is the way I always think of it. And the planning board went ahead and reviewed the application, followed the seeker process, issued a negative declaration, had public hearings to get comments on the project as well, and then ended up approving the application for approving the site plan application and issuing a special use permit. So petitioners were unhappy